Resurgent India Knowledge Series in collaboration with Resurgent Resolution Professionals LLP, IP, presents Virtual Session on Insolvency Proceedings against Surety. Moderator Mr. Sunil Gupta, Vice President, Resurgent Resolution Professionals LLP. Eminent speakers: Ms. Vandana Garg, Practicing CA, Insolvency Professional; Ms. Ria Luthra, Founder, RTA Law Chamber; Ms. Harmeet Kaur, Practicing CAs and Lawyer, Insolvency Professional.
Good evening, ladies and gentlemen. A very important topic that the corporates and the guarantors are facing today is the insolvency of personal guarantors. The code was basically enacted to resolve the insolvencies on a fast track, supported with the maximization of value of the assets of the corporate debtor. It was basically to bring the companies under stress to come on their own feet as a going concern and contribute to the economy of the country with the entrepreneurship. And we see generally the lenders are taking guarantees against the loan from the promoters, from the directors, and sometimes when there is a third party security from the third party. Now, in this case, the debate is whether the insolvency, when individual insolvencies of individuals is not there, whether for guarantors it can be done. Yes, it has been established by some decisions by the Honorable Supreme Court of India, and it is interpreted that it can happen. Now, there are certain key issues which are embedded into this process, and that's why Resurgent has tried to bring this for discussions with the eminent panelists. Going further, I'd just like to share some inputs of the eminent panelists that we have today. I welcome Ms. Vandana Garg. She's an insolvency professional. She's a seasoned professional with more than 24 years of experience in corporate finance and corporate strategy advisory. She has resolved debt of more than 9,000 crores single asset across industries. She's a fellow member of Institute of Chartered Accountants of India, a law graduate, and holds certifications in IT, audit and forensic fraud detection. She is recognized for her ability to drive performance, deliver high quality outcomes. Welcome, ma'am. Welcome to this webinar, and thank you for joining.
Thank you. Thank you, sir.
Now I come to Ms. Harmeet Kaur. She's a practicing chartered company secretary, a lawyer, and an insolvency professional, as well as an independent director. She has 2 decades of experience in the corporate secretarial, legal, and financial areas. Again, she is currently practicing chartered company secretary and a process advisor in various stakeholders of IBC. Ms. Kaur is graduated from Sri Ram College of Commerce and a postgraduate diploma in business administration and computer application. Welcome, ma'am. Welcome to this webinar.
Yeah.
Let me come to my next panelist, Ms. Ria Luthra. She is the founder advocate of RTA Law Chambers, Delhi. She is specialized in dispute litigation and advisory, having extensive experience in advising clients under various statutes, including insolvency, and arbitration. She represents clients before Supreme Court and definitely other courts. She's also a legal retainer with the State Bank of India, a very, very prestigious position that she's holding. Welcome, ma'am, for in this webinar, and thank you for joining.
Thank you, sir.
Thank you. Thank you, sir.
Ma'am, we all appreciate that this is a topic where individual guarantors are concerned. Previously, there was no law when the guarantees were given. And definitely, the intent was very clear. They want to repay the loan. However, having said that, now a law is in place. A lot of people in the country would like to understand from us uh, what are the process, what are the repercussions, what are the rights. So what we'll do is we will take certain key questions into this webinar. We'll try to answer them for sharing our knowledge with my participants. Manna ma'am, first of all, I'll just like to have your views in why this personal guarantor of the corporate debtor category added to IBC itself. Because when there is no insolvency permitted for sole proprietorship, partnership forms, so what was the need for adding this, particularly for personal securities, I'm saying, not the corporate sureties? Ma'am.
Thank you, Sunilji, for giving this opportunity to me to explain to the audience about the personal guarantee. There were various interpretations happening in the financial world regarding the personal guarantee. Tribunals were also giving multiple interpretations in the last couple of years regarding the personal guarantor and the corporate debtor. So eventually, there was one case which was SBI versus Ramakrishnan, which actually gave the finality on the personal guarantors. They said the important aspect for determination to derive at the correct finding was whether moratorium under Section 14 is applicable to the personal guarantors or not. So in those cases, what happened that the moratorium is not applicable to personal guarantor, and that's why this section 3 was introduced by the code. Section 2018 amendment modified section 2E, which said that the three categories of individuals will be included. One is the personal guarantors, second is the partnership firms and the proprietor firms, and the last is other individuals. That is the reason, because people were taking advantage of section 14 moratorium, and clearly IBC specified that the personal guarantors will not be included in the section 14 moratorium, and that is the reason section 2 was amended in 2018 Amendment Act. So the liability of the surety, why this happened is also important to understand. That section 128 says that the liability of the surety is coextensive with the principal debtor. Because of that, the lenders were having the practice, as you rightly said, lenders were having the practice of obtaining the guarantee, the personal guarantee from the promoters of the corporate debtors. The personal guarantor is liable to discharge the debt obligation of the corporate debtor in accordance with the terms of the guarantee. So, an agreement, whatever agreement they execute, they were binded by that. So, in this provision, in section 128, this particular section 2E was introduced by the code. And there was a Supreme Court overturned the order and said that the moratorium is not applicable to the guarantors to the corporate debtor. The court also found that the provisions were simultaneous proceedings against the corporate debtor and personal guarantors will be there. So in these cases, that is the reason why Section 2E was introduced, and this particular provision was introduced by the court.
Thank you very much, ma'am. I think it gave a lot of insights on why this amendment has happened. And now, after 2018, the personal guarantors are equally and simultaneously liable. Rather, if we see, actually, even if there is no CIRP started against the corporate debtor, the personal guarantors, the insolvency can commence against the personal
Yeah,
guarantors.
to bring in the more
Uh,
clarity and to distinguish the two proceedings and to have the simultaneous proceedings with these two separate codes. That is the reason why this particular section was introduced.
Thank you, ma'am. Ms. Ria Luthra, I'd just like to just get insight from, see, what is the jurisdiction for initiation of insolvency process, particularly of personal guarantors? Because what happens, the corporate debtor is having a registered office, whereas the personal guarantor may be having 3 or 4 residences. Number one. Number two, there can be different personal guarantors in different jurisdictions. Somebody may be sitting in Maharashtra, somebody may be sitting in staying in Delhi, somebody in remote area of India. Now, if there are multiple jurisdictions for the personal guarantors, which address? So I'll just like to understand from you what will be the jurisdiction of the for that insolvency process to is commence, under which NCLT it will come. If you can just throw light on that.
Absolutely, sir. Thank you so much for this question. This is a very relevant question, as you had pointed out that there could be personal guarantors based out of different places in India. So for one particular loan or one particular debt, there can't be multiple insolvency proceedings that are going on in different parts of the country. It has to be one consolidated because all of these personal guarantees are arising out of one singular debt. So it is section 60 of the Insolvency and Bankruptcy Code, which relates to the jurisdiction, the territorial jurisdiction of these debts to fall in which particular place. Now, section 60, it very primarily states that the adjudicating authority in relation to insolvency resolutions with respect to personal guarantors, with respect to creditors, be it operational creditors or be it financial creditors, will be the territorial jurisdiction where the registered office of the corporate debtor is located, the corporate person is located. So it basically means that an application for initiation of insolvency for personal guarantor has to be filed before the NCLT, which has the jurisdiction over the registered office of the corporate debtor. For example, the corporate debtor here is let's say Messrs X Private Limited, which has its registered office in Oakland, New Delhi. The personal guarantor uh, may be a subsidiary company of its, which has its registered office in Bombay. But in case we have to invoke a jurisdiction with respect to the debt that has been availed by the corporate debtor, it has to be before NCLT Delhi and not in a different NCLT. Now, there could be also a case where there is already a insolvency proceeding which is pending in Bombay and insolvency proceeding against a corporate debtor pending in Delhi. In those cases, the insolvency proceedings which have been initiated against the personal guarantor has to be mandatorily transferred to NCLT Delhi so that it could be one meaningful litigation with which they can be one singular resolution.
I think that is a very good insight with the example. I think you explained very well. Thank you, ma'am. It's very important because see, not normally what happens that I'm sitting in Bombay and I may have 3 addresses. Number one, number two, I may change the address over a period of time. Now, in my registered or the records, I may be having an address as a personal guarantor into Delhi, but later on I shifted to something like Patna. Now, it will be very difficult for this resolution professional or even the person who is initiating the process. So, and I think it's very good and it's very logical also that we have at the place where the corporate debtor is having its registered office. Coming to Ms. Harmeet Kaur, ma'am, I'd just like to understand, can a resolution plan, if it is approved for the corporate debtor, now normally what happens, the corporate debtor, wherever whosoever is the resolution applicant, they say that all liabilities etc. are settled and they are practically, we see that all the liabilities are settled. Now, if all the liabilities of the corporate debtors are settled, uh, then effectively it means that there is no liability on the corporate debtor. And this liability of personal guarantor is actually emanating from the corporate debtor itself. Now, I just like to understand from you for the knowledge of my participants as well. Can approval of resolution plan of the corporate debtor discharge the personal guarantor because that plan has been approved? Now, the liabilities have been settled as far as corporate debtor is concerned. Is he or she gets discharged from his or her liability? Ma'am, you are on mute. If you can unmute it, please. Thank you.
Yes. So thank you for this question, sir. But I would like to draw your attention to an important aspect here. Uh, Up to a few initial years of IBC, we were actually advising, and some personal guarantors were advised in this manner, that extinguishment of all the liabilities with the approval of the resolution plan by the NCLT or thereafter at NCLAT or whichever level. So once the plan is approved, the liability shall extinguish. But the actual status of that liability is it is getting extinguished against the CD, and CD won't be having further actions against itself, and the new management shall not attract any further actions against them for those liabilities. But that is an act of law, and it is not a voluntary discharge of liability of the guarantors. So whosoever is the personal guarantor, or for that matter, even the corporate guarantor, shall continue to carry those liabilities. And it has been well settled law by now, since we have seen in first in the SBI versus Ramakrishnan matter in 2018 itself, while this notification of personal guarantor rules, etc., were not there. Even prior to that, in that matter, it was observed by Honorable Supreme Court that the language of Section 31 of the Code has clearly included the word guarantor. So the plan shall be applicable on guarantor, but the approval of the plan would not discharge a guarantor of his or her liability under the contract which it has entered independent to the CD, because the guarantor is an independent person, is a separate legal entity than the CD. If the CD is getting discharged, that would not automatically discharge the guarantor of his or her liabilities. Thereafter, even in Lalit Kumar matter, Lalit Kumar Jain matter, Innoventive, the supremacy of IBC has been established over Contract Act, even while initially the Contract Act provisions under 128, 133, 134, and for that matter 135 were also being used to say that discharge of surety shall be there while the principal debtor is being discharged, or when the terms of the contract are changed without the knowledge of the surety, then he should be discharged. But all those sections were in conflict with the 238, and the supremacy of IBC prevailed. And now it is a res judicata that with the IBC, with the plan approval under IBC, only the CD's liabilities are getting discharged, and that too, whichever liabilities have been recognized in that plan, those debts are extinguished, and no further action shall be taken against the CD for those loans. But the personal guarantors or the corporate guarantors can be, sued, can be an action under various laws, whichever remedy is available under limitation, etc. So those actions can still be taken against those guarantors even after the approval of the plan.
A supplementary question to what I was just asking. See, is it possible that the resolution applicant, whosoever is there for the corporate guarantor, if he or she can, they can ask for an assignment of the personal guarantee against which they can make a separate payment or separate provision in the plan without being conditional plan. Is it possible to get the assignment in their plan so that the assignment of the personal guarantees come to the resolution applicant rather than the banks? Is it possible?
Yes, sir. In case the lenders who are the financial creditors who are part of the COC, they have approved it along with those conditions which are not making the plan conditional in their view, and they have approved the plan as it is, and the assignment is approved through the plan. And thereafter, the adjudicating authority has also found the plan in compliance of the law, and it has approved the plan. So the assignment of liabilities as well as the change in the guarantors can take place, because assignment of loan has taken place. So the new agreements have to be signed new loan agreements, new contract guarantee agreements have to be signed in pursuance to the approval of the plan. So under those, all those conditions which have got approval of the COC as well as the adjudicating authority shall get reflected, and in pursuance of that approval, new lender as well as not new lender, new assignee as well as the guarantors can enter into new agreements and shall
Thank you
be,
very much for that insight. Yeah, please continue, please.
yeah. So any other question regarding this?
No. Thanks. I think that is a very good insight because see, we are seeing that a lot of plans are coming, and there is one condition in the code itself that a plan cannot be conditional. That's why I just put this case. Is it possible? Uh, Arya man, I'll come back to you. See, particularly in case of in personal insolvency, there is a principal debtor, which is a corporate debtor in this particular case. Now, can the personal guarantee or personal surety can be invoked uh, against a personal guarantor without any initiation of CIRP against the principal debtor? Is it possible in the
Yes,
law?
absolutely. So, like we have read the Contract Act, Section
Hmm.
128 of the Contract Act very specifically mentions that the liability of a principal debtor and of the surety is coextensive with each other. It is not that upon failure of recovery from the principal debtor, then we will have to approach the guarantor. Both of them can be evoked simultaneously. So, as per your question, there is no precondition of pendency of insolvency resolution process or liquidation against the corporate debtor for filing any application under Section 60, and there is absolutely no necessity to dwell into on any submission of such fault. The creditor may initiate proceedings against the principal guarantor against without even invoking any insolvency proceedings against the debtor. He may do it after initiating insolvency against the principal guarantor, or maybe simultaneously with both. There's no bar, there's no timeline defined that how do you have to approach with respect to insolvency of a debt. Even the Supreme Court of India, in a very recent landmark judgment of State Bank of India versus Ramakrishnan, and very specifically mentioned that the liability of the principal debtor and the surety is coextensive with each other. It is joint and it is several, and it can be invoked at any point of time after default of debt.
I think this brings a very important point which you have given. See, a corporate debtor, if is having a lot of assets, fixed assets, which can be in cash, like land, building, property, etc., is there, and the lenders can go into surface without initiating the CIRP against the corporate debtor, and they can recover a lot of money out of that because then whatever amount remains is practically either the inventory or receivables. And our experience also says that these are practically not recoverable. A very
Absolutely.
minuscule
It's a
amount is
very
recovered. It's a very good tool as well as as far as bank is concerned. They can recover from surfacing the physical assets, and then they can go for the personal insolvency directly without initiating the CIRP, because again there is a lot of cost in CIRP involved, and they can go for a personal
absolutely.
insolvency, and the law allows that.
Any which ways, an insolvency resolution process is very lengthy and very cumbersome. It cannot be completed, and you can't have a timeline. Although we have timeline of CIRP, but in practical, we have always seen the CIRP getting extended because there's so many claims coming in, verification of so many claims, inviting applications. So it becomes a very cumbersome, very time-taking process. So in the meantime, the creditor who has advanced a huge loan of money and has to have a different or has to have an additional mode of recovery also. And if the now after this personal insolvency against personal guarantors has been invoked, I think banks are doing a great job in recovery. And plus, the loans have also become more efficacious in the sense that they are doing their proper due diligence before giving the loan, because they know that one default will also garb in their personal guarantors here. So a lot of things come at stake.
Thank you, ma'am. I'm just taking forward to Ms. Kaur in that
Sure.
it's a relevant question connected to the earlier question, but I am taking it with Ms. Harmeet Kaur. See, a CRP is running against the principal debtor, corporate debtor, can we initiate the personal insolvency? Because you will also appreciate that you will appreciate that, see, we don't know what amount will be recovered from through CRP, and at the end of the day, a lender cannot recover more than whatever has been claimed. So a CRP is running, we don't know what will be the amount that will be recovered from the principal debtor. Now they are also initiating. Is it fair? Is it possible? First of all, I'd like to know legally whether it is correct that the surety, the personal insolvency against the surety can continue while the CRP is parallelly running.
Yeah, so as Ria has correctly told that the CRP, the personal insolvency resolution process can be initiated even prior to the CIRP of the CD. I must say that it is allowed legally, there is no problem. While a CIRP against a CD, the principal borrower is being carried out, while during that CIRP period itself, a case can be initiated against a personal guarantor or the corporate guarantor of the same CD against the same debt. What is debarred, what is not allowed is only the double debt. That what do we mean by that? Double dip is that we cannot recover more than what we have lent and for the amount of debt. So the amount of debt remaining the same, one cannot recover. If you cannot recover that from a CIRP, from a CD or an RA in a particular process of the CIRP, you are allowed to have to carry out the action against the guarantors to cover the remaining part of the debt, which remains unpaid even after the complete process or even prior to that process. So what is debarred is the recovery of more than of the amount more than what you have lent, but not the uh, recovery proceedings. They are not barred. So you can either initiate a case against the guarantors prior to CIRP, against that principal borrower during the CIRP, or even after the plan is approved. So this has now been settled, well settled by various judgments also, that recovery from the guarantors and personal initiation of the personal insolvency against the guarantors can be initiated at any stage.
And this brings a very important question relating to again to the CIRP itself. For example, if I can my total debt claim is 100 crores, I could recover, and against both I have started initiated the resolution. I got 20 crores out of that from the personal guarantor. Now, would I be going back to reduce my claim in CRP to 80 crores?
I think in case the entire resolution, the repayment plan by the personal guarantor has been implemented successfully, and you have actually received the payment, then you must file that and update that in the existing recovery proceedings against the same principal borrower, because the same debt has to be, the amount of debt has to be then updated over there. And in your claim, in the resolution plan, in the IM, everywhere that update has to be made in that running process.
Definitely, but definitely there will be some conflict can happen if the timings are same. There is a possibility. I think yeah, everybody will agree that there will be a possibility that if simultaneously the process is running, there is a possibility that the resolution plan is also getting executed, the repayment plan is also getting executed, and there is a dilemma to ensure that the amount should be recovered. That should not be double dip, or the excess amount should not be recovered. And
So
we are not sure whether it will be recovered or not. But then
since
maybe in future
the process has just started, sir, we'll see many more practical challenges going forward. So
exactly,
till
that's why I'm
now
saying
the
the practical
concepts were
challenge.
being clarified. Yeah.
Yeah, practical challenge. We will find over a period of time that where the payment will be done. Ultimately, if there is an excess amount, what will be one?
There won't be.
Okay, there is a very small question coming from Ms. Karma Bhutia, which says, can a proceeding be initiated against a partnership firm? If so, which demand notice format to be issued? So I just like to answer that. See, normally against if it is not an LLP, limited liability partnership, the it cannot be initiated unless and it is a corporate. It's a personal guarantor. It's a guarantor. If a partnership firm is a guarantor, then it can be initiated. But if as a debtor, principal debtor, it cannot be initiated. Vanna ma'am, I'll come to you. It's again a very important question, because see, if a personal guarantor is paying some amount on behalf of the corporate debtor, now normally we see that there is a subrogation, right of subrogation, where he or she can claim it from the corporate debtor. So I'd just like to understand whether the surety has the right of subrogation or not, in particular in case of CIRP, as well as in case of the personal insolvency.
Sir, right of subrogation is a right to the surety, which says that the payment which is defaulted by the corporate debtor, he can recover it from being in the shoes of a creditor. He can recover it from the reimbursements to either to from the promoter or the corporate debtor itself. But however, this is a right, but this has been denied in IBC. And this is what is shocking for the corporate guarantors, that right of subrogation was a right, but it's not something which IBC has recognized it. The rationale is that in case they grant the right of subrogation, then they will be stepping into the shoes of again the creditor and asking the resolution applicant the money. So that will be difficult for the revival of the company, as the resolution applicant or the new buyer will have to pay the same amount of debt to the particular guarantor. So the NCLT in this case has observed that providing the right of subrogation would give the powers to the promoters who contributed to the insolvency of the entire process. So in it was for these situations, the opinion of the court was that the the specific and pertaining to particular cases, that this should not be given to the guarantors. The law of subrogation should not be there for the guarantors in such a case, because it will put them into in a advantageous position. This was clearly, sir, established in a case which is COC of SR Steel versus Satish Gupta. The judgment, among many issues, they dealt with this issue of right of subrogation of guarantors. They said that the guarantors filed the claim of reimbursement from a resolution applicant in order to exercise the right of subrogation after creditors invoked their guarantee. Supreme Court denied clearly that the right and held the guarantors does not get discharge of his liability even after approval of the plan. The creditor can still pursue the remedies to recover the contract amount from the guarantor. So that right of subrogation is not granted. And the guarantors definitely will have suffer the setback, as a major principle of law of guarantee was denied to them. And definitely they cannot put into the reimbursement in this case. So in the event of a repayment on behalf of borrower, so this right was clearly denied.
And I think I'll just add to it. It will right of subrogation means practically coming into the shoes of the lenders.
Right.
Of a secure lender, if they come into the shoes of secured lender,
Hmm.
so they also have the priority under Section 53(1).
Sir, they
So
cannot come
if
into the
the right
shoes
of
of a secured creditor. They will, because there is no security. The deed of guarantee is not the security. There is no charge on asset which is created in the contract of guarantee. The only recovery mechanism is through his personal assets. But it doesn't mean that he has got the shoes of a secured creditor. They are the creditor, but they're not the secured creditor.
Yeah. Thank you, ma'am. Thank you for this clarification. It's very, very important, because wherever there is a challenge, particularly from uh, wherever there we are finding there are challenges, because a lot of conflicts amongst the law is there, and we also know that the code has superiority as far as our other laws are concerned. So I'll come to Harmeet ma'am in this case. Now I would like to understand, because in this case also the resolution professional is appointed. In CRP and liquidation process, we have seen a very important role as a court officer. The resolution professional acts. It acts though under the guidance of COC and SCC, as the case may be. What is the role of resolution professional in the matter of personal insolvency, ma'am? If you can just give us a throw light on that.
So first of all, in case of insolvency resolution or through of a personal guarantor, let me just give you my views that it is not exactly a resolution of something. It is not a recovery. It is actually um, a, a survival question for that person. If you consider, if you think of a person whose assets have been given as a security, which are subject to surety, who has given his personal guarantee that I will repay that loan of thousands of crores. So if you consider it from that perspective, I consider the insolvency resolution process, as the name goes, of the personal guarantor, a chance to him to come out of that debt situation, which is actually not his debt. And it is a huge debt taken by the CD in whatever manner, in whatever circumstances he has got into that agreement and he has become a guarantor. So now it actually helps him as a person to come out of that situation, and he can offer his own repayment plan. So it is a kind of a settlement. It is not exactly a process which an RP is running. So from an RP's perspective, there are not much of powers. He is only a facilitator. So I should, go through some of the observations that have been made by Honorable Supreme Court in Dilip B. Jwajka case. And I think everyone who is going through personal insolvency matters or taking them those matters or a part of the process in any manner must go through that, because it has clearly laid down a distinction between the what an RP is expected to do under a CIRP process, under Part 2 CIRP or a liquidation process, and what is expected out of him under Part 3, because he's only facilitating the process and helping the personal guarantor to come out of that situation. So the guarantor is identifying his debts, guarantor is presenting his assets, and he is giving a plan. The RP is only helping him out. So the order somewhere says that AA is also not having adjudicatory role here. AA only has to appoint an RP. So RP is empowered to seek further information or explanations from whosoever he considers that maybe that person is important, or he may be able to provide that information, to examine the application made by debtor or the creditor in this matter and submit a report, either recommending the approval or rejection of the said application. And the RP is only examining the application. The words used in the act, in the code herein, have been to examine and not to adjudicate or to find out any claims or just a minute, sorry. So here he's only ascertaining and he's only satisfying the requirements of the law. He's only recommendatory. He's having a role of recommendatory nature, and not exactly where under the CIRP where he's having to take possession of the assets, to take control of the business. It is not a CD. It is a person. You cannot take control of a person. A slight distinction is there in the bankruptcy process, which we are not discussing over here, but I should touch some part of that, because there he is acting as a trustee on behalf of that person. He is running the show as a trustee. He might be continuing his business. He might be engaging himself back to continue his business. He might be having some investigative authorities. But here, under insolvency resolution, he is essentially helping him out to give a settlement plan, a repayment plan that is called. So I think
What
basic
you
difference is that.
what you actually mean is कि in this case, particularly in this case, though in CRP also it is helping the corporate debtor come out of the distress. It is not they want to run the show as the creditor actually steps into the shoes of the promoter. Here he practically acts as a friend of the personal guarantor to
Actually,
help him
yes.
out of this debt. And
Yes.
I think this role is very, very important because it is not obligatory on his part to investigate into the things, and that I will take later on. But the thing is, ki, yes, it is he's just helping out under within the framework of law, the personal guarantor to come out of the stress, and so that he can live his life, further life without any stress of this
And
particular debt and
and
a sword hanging over his head.
yes, and with debts he is disclosing, it is for his benefit. One has to just explain him the process that whichever debts are included, of course not the excluded debts, but those debts shall be discharged, and whatever assets he's not disclosing, but there are some records that those assets exist. There are penal provisions for that. So RP, in a way, is a bridge between the law and the person. So he's explaining to him how he can get discharge of his debts through this process.
Thank you very much, ma'am. Vandana, ma'am, I'll just come to you.
Yes, sir.
See, in personal guarantees, because see, under CRP there is a clear-cut process that you have to file a first you have to give a notice, and then under the notice, after the notice, if it is not responded, the debt is not paid, you can initiate debtor creditor can initiate the process, CRP process under section 7 or 9. I'm not saying about 10. I'm not discussing that, but if there is a default, and this can happen. In case of personal guarantee, can can a claim be based on an uninvoked guarantee? If guarantee is not invoked by a creditor. Now, there are normally what happens, there are a lot of creditors, particularly in case of personal guarantees, because it is linked to the corporate debtor. A lot of creditors are there, individual creditors are also there. Now, the guarantee in one case or two cases, because of one is lack of information, the knowledge with the lenders. Here we may also have some lenders attending this webinar. One is because of lack of knowledge. Second is because normally what happens, and normally large lending is done in consortium. Now in consortium there is only one agreement, and then there is one lead lender who is keeping all the records, or there is a security trustee where the trustee is having all the records, all the agreements, etc. And individual lenders may, because either lack of knowledge, or maybe because that they think because there is a trustee and we are in consortium, they are not invoking the guarantee, their respective guarantees against the respective personal guarantors. Can we accept, can a resolution professional accept a claim of uninvoked guarantee?
Sir, it is amply clarified in couple of judgments, especially Swiss Ribbon, sir, that it is that for the initiation of an insolvency resolution process against the personal guarantor, the creditor should invoke the guarantee by serving a demand notice. There are some particular forms which are given in the BG rules, but the invocation of guarantee is of utmost importance. So a claim has been clearly defined in Swiss Ribbons. I'll just read out the claim for you. Swiss Ribbon said the claim give rise to a debt only when it becomes due, and the claim is wider in definition than the debt. A claim may be due or may not be due, but a debt must be a claim which is due. The claims are filed by the applicants in various cases, but it was decided by the tribunal that the applicants cannot claim the amount in the CRP of the corporate debtor who is a corporate guarantor on the basis of a deed of guarantee, which was never invoked as on the date of filing of the claim. So it is clearly given in the Supreme Court judgment, which was Swiss Ribbon's judgment, that the in guarantee should be invoked. In one of the other judgments, which is Ghanshyam Mishra and Sons and Private Limited with the Edelweiss, it is also seen that the uninvoked guarantee cannot be considered as a matured claim. So that once the moratorium was applied under Section 14, a corporate guarantee cannot be invoked. So this is clearly at various instances and precedents, it is given that the guarantee has to be invoked. A notice has to be given, a proper procedure has to be followed, and we have to clearly demarcate that the claim has become due to you. The principle of corporate guarantee cannot be invoked once the CRP has commenced, and that uninvoked corporate guarantee as on date of filing of claim cannot be considered a mature claim, and that's why there is a utmost important that we should invoke the guarantee before the initiation of the CRP process.
There are two related questions, ma'am. I'll just like to add to it. One is, in this case, see what you are saying. For example, company X is having already CRP has initiated. Now, and they have also given, X is also given a guarantee against in the matter of company Y. Now the guarantor, the beneficiaries of the guarantee of company Y cannot initiate any claim. They cannot invoke the claim once the CRP of company X has started. Okay. Now in the similar question that I want to clarify is, a personal insolvency has been initiated against me, for example, and by X Bank. Now, X Bank has invoked the guarantee against me, and they have initiated the PIRP against me. Now, there is a claim of Y Bank also, because I am guarantor to them also. Again, the same corporate debtor or maybe another corporate debtor. But that guarantee, if it is not invoked, can the claim be accepted by the resolution professional? That I just wanted to understand, whether it is possible that the guarantee of Y Bank has not been invoked, but they have just submitted a claim because X Bank has already initiated the personal insolvency against me. Then
So yes,
can we?
the claim can be accepted.
Okay, claim can be accepted. That's very good point, because sometimes what happens is there's a lot of litigation is going on this matter. So I just want to, that's why I brought this matter to you for your so that wisdom can be spread.
Because, sir, if the proper procedure of giving a notice is followed, the proper deed of guarantee, it is also dependent upon the deed of guarantee, sir. If the deed of guarantee says that on demand it will happen, then on demand. If the notice has to be issued, then notice has to be issued. It is all based on the guarantee agreement, whatever has been signed by the lenders vis-a-vis the guarantor. So if both these things are matching and the proper procedure is followed, then the initiation of CRP can happen, and the claims any which ways will have to be filed.
Okay. Ms. Luthra, I'll just come to you again. Very ticklish question that I am putting up to you is the applicability of limitation of initiation of CRP, particularly of personal insolvency, because in CRP we know there is a law of limitation which is applicable, and a lot of litigation and a lot of judgments are there. Jurisprudence is available on Limitation Act. Now, whether this similar applicability of limitation law is there in case of personal insolvency, can you just throw some light on that, please?
Absolutely. So basically, there's Article 137 of the Limitation Act, which says that the time from which the period begins to run to file a claim is when the right to apply accrues. Now, here, what is important for us is to understand what is right to apply. Now, there is a corporate debtor who entered into a loan agreement with, let's say, State Bank of India, availed a loan of, let's say, 10 CR, in which X Limited Company is a personal guarantor. Now, according to the loan agreement, the repayment has to be done by virtue of EMIs that the corporate debtor has to pay to the bank. The corporate debtor defaults. How is the guarantor supposed to know that there has been a default? The bank, the debtor, sorry, I'm so sorry. Guarantor will only get to know when the bank claims that amount from them or demands that amount from them. So the right to apply will occur when we demand it from the guarantor and then the guarantor doesn't pay up. So if you generally see what happens in deed of guarantees, there's specifically the clause which mentions that the guarantors agree and undertake to pay and satisfy the bank on demand, and interest will be payable thereon from the date of demand. Because until the date of demand, you have not really claimed anything from the guarantor. So the guarantor is not liable to pay. The guarantor may be sitting in a different city altogether, who has no aware of a default that has happened, and the bank doesn't inform. And without any of this, they are filing an application. So you basically never gave the guarantor an opportunity to repay you. That opportunity only comes when you are raising their demand. The Supreme Court of India, in a very prominent case of Syndicate Bank versus Channa Veerappa Bellary, has very clearly stated that the guarantor's liability will depend upon his terms of contract, because it's an absolutely different, separate legal contract which they enter into with the guarantor. Now, whether the guarantee agreement only specifically says that the guarantor is liable to pay an amount in case of default limited to 5 crores. Let's say it's only for 5 crores, where the loan amount is for 10 crores. So in those cases, the demand cannot be in any which manner more than 5 crores. And when will the demand arise is when the default happens in the bank demands. So basically, it is well settled that the loan agreement with the principal borrower and the bank, as well as the guarantee, are two different transactions, and the guarantor's liability will only come out from the reading of the deed of guarantee and initiate and commence from the date of demand. So this is when the limitation rule comes into play in respect of any insolvency initiation proceedings against a personal guarantor.
Thank you, man. Thank you for the insight. Ms. Kaur, I think it's a related question that I'll just type your thoughts on whether there can be a time barred claim, particularly in case of personal insolvency. Though it is very limited, very linked to the earlier question. I just like your thoughts on can there be a time barred claims? Harmeet ji, you are on mute. If you can just. Ma'am, am I audible? Harmeet, ma'am, am I audible to you? Vanda, ma'am, am I audible to you?
Yes, you are audible, sir.
I think.
Harmiji, is Sunilji
I
audible?
think there is some audio problem that's on the other side.
Okay. I'll just repeat my question to you. It's related to the initiation of insolvency, particularly the limitation. So, Harmeet, ma'am, am I audible? Otherwise, I'll just take another question. Vanda, ma'am, if you can just throw light on the same. There is a related question that
Yes, sir, I can write
to
it.
the limitation. Can you just throw light on this time barring of the
The time barring,
claims?
it is very crystal clear that the claim cannot be rejected because it is time barred or it is claimed by entity other than the financial creditor. So it is clearly been established now by various procedures, precedent, judicial precedents. So this is all already been given that time barred claims, the parameters limitation are to be seen in the case of filing an application for initiation of insolvency proceedings. But time barred claims can be admitted in the insolvency proceedings. So,
Okay.
There cannot be a rejection on the basis of a time bar. The judgments are there, like Punjab National Bank versus Surendra Prasad Sinha, that the rules of limitation are not meant to destroy the rights of the parties. So, in those cases where the rights to enforce the debt by judicial process is barred, the right to debt still remains, sir. The time barred debt does not cease to exist by reason of not being enforced. That is the reason it cannot be rejected.
Another question to you, I'll just like to answer, get it from you. Can a resolution professional see as we discussed earlier that resolution professional is basically a bridge between the law and the guarantor or the surety. Now, there may be a possibility that resolution professional understands from various other sources that there are certain assets which has not been declared. Um, there are different grapevines which are there. Um, can does he have, particularly in the matter of personal insolvency? I'm not going into the bankruptcy. We'll like to have another session on bankruptcy. In personal insolvency, can a resolution professional investigate into the assets? Can he or she enter into some investigative authority shoes and then investigate the assets of the to find out if there are assets which have not been declared in any of the documents? I'm not saying about document because if any document is in my hands, I can definitely ask. See, this was the document which is available, or your bank statement. You have purchased shares. You have not declared your share. Whether you have sold or you have transferred, you have to just but whatever documents that I don't have or it's not apparent in my knowledge, then can I investigate as a resolution professional the assets of the
So
personal
yes,
surety?
sir, my answer to that question is yes, because of various reasons. There is a possibility there are substantial evidences in the books of accounts that gives a clue to a research professional that the assets disclosed in the statement given by the personal guarantor are really not sufficient to sufficiently disclose. That could be one possibility. Sometimes research professional do that suo moto, but most of the times they do with the COC's concern or the claimant's concern, because ultimately the research professional is responsible to the COC members. Generally, resolution professional will ask the personal guarantor to give the entire set of assets. As in this case, he acts like a friend, as we discussed in the earlier session. However, if there is a substantial evidence that the person is not disclosing the assets properly, or there are evidences in the books of accounts that gives a clue or the suspicion to the resolution professional that he should go ahead with the asset tracing, then we have also seen at various places and cases that the asset tracing happens and religious professional can take the action. It all depends upon case to case and circumstances of the individual personal guarantor, how transparent the guarantor is. If they're not transparent, then RP will take the action based on the COC's consent or giving the information to the COC. So that way, it all
Yeah.
depends upon case to case.
Ma'am, that brings me to the last question because we are just running out of time. But I'll just share with everybody, all my panelists, a very important question that is coming to my mind is in my repayment plan, can a personal guarantor ask for or request for certain reliefs and concessions, like we are getting, or we are a clean slate principle that we are getting? As far as resolution applicant is concerned, it is okay. But see, as a personal guarantor, once I am giving a repayment plan, now as I would also like to have a clean slate, that there are no litigations except for criminal litigations. My all litigation should be removed, or the check bounces cases should be removed. I'm just giving you clues. So I'll take 1 minute each from each of you, because we are running out of time. If you can just throw some lights, I'll start, Vanda ma'am, from you, about the reliefs and concessions, particularly for personal guarantors.
The personal guarantors definitely, when they're giving a clear-cut repayment plan, their life should start from the clean slate that is agreeable. They can ask for the relief and concession. Now it all depends upon the AA and NCLT, that or any other forum, that they give the relief and concession or not. So it is all dependent again on the various circumstances, or the cooperation extended, or the assets disclosed. They can any which ways ask for the relief and concessions, because they have the right to live after the plan is given by them based on their best possible efforts. So from my standpoint, or my point of view, they definitely can ask for relief and concessions based on their own individual risks and liabilities. So they can ask.
Ma'am, Harmeet ma'am, there is a very related question which has come on my this. Can the 138 NI Act proceedings and IBC proceedings can run parallel? I think this can run parallel. There is no problem. IBC proceedings and 138, it clearly IBC says ki any criminal act will continue. The moratorium is not on criminal act. So I think, Karma ji, your question is answered. Harmeet ji, on this reliefs and concessions, if you can throw some light.
Yes,
1 minute
I
to you, please.
definitely agree with Vanna ma'am. And he must ask for the release and concessions because he has to get a discharge, and thereafter he has to start his own commercial, social life as well. So being an insolvent, whether discharged or undischarged, is not considered acceptable. That tag itself is a taboo in this society. We are not US or UK. We are not evolved enough out of this concept as yet. It has just started, and the society may not accept that. One is from that perspective, another is from actual business perspective, where he has to get fresh loans. He should not be debarred. He should be, able to run his businesses or start afresh. Whatever commercial reliefs, whatever economic reliefs he would require, whatever financial grants he would be needing in future, because right now he's applying his entire asset revenues towards the payment of debts of that CD. So I think he must ask for that, and IPs and advisors and advocates must, suggest him, recommend him to ask for those reliefs, because our society and our financial system is yet to, develop itself to those levels, and it would not automatically come to him. So an order in
Thank you,
that
ma'am.
respect would
Thank
help
you
him.
very much, Vanda ma'am, Harmeet ma'am, and Ria ma'am. Thank you very much for this very great insight. I would just hope that my participants gain from it. We can also answer your questions on mail. Now I will not be able to take further questions. Thank you very much. And it was pleasure having you here.
Thank you, sir.
I hope
Thank you.
my members were satisfied with the discussion that we had. Thank you very much.
Thank you, sir.
Thank
Thank
you.
There is a question from Akanksha. Yes, there can be two suits with the borrower as well as the co-borrower at the same time. Okay, thank you very much, ladies and gentlemen, for joining. We'll be putting up another round as soon as possible to share. Thank you.